Before we start, let's have a look at this lovely diagram that Rachel has created in a sort of a little bit larger version of that so that we understand more clearly where we are at the moment. Because what I find quite confusing in our procedure is that everybody is an officer of one way or another, and then you just don't know what it is that you're actually meant to be doing. So what's been discussed so far is on this side of this graph. Okay, up till here, and now we are entering the secondary phase when the case has been referred to the hearing committee. So what I'll cover in this session is if you are appointed a presenting officer, what happens, okay, what is great about the role, but what are also the challenges, and how to act as a member of the hearing committee, including chairing committees and handling the representatives, which some people may find sometimes a little bit off-putting or at least anxiety-generating, quite unnecessarily. Right, because I wanted to provide you with some kind of useful guide when you actually leave this session and start writing cases, you will see there will be a lot of lists, and I don't propose to go through those lists. I created a handout for you to take away, and this is really all you need to have when you're writing the case. What I would like to tell you is a little bit of context so that you do understand how those committees work, what is required, and I'll touch on a little bit on the fairness issue, because many people who are not familiar with how committees work see fairness as a 100% concept, which makes their life and their work very difficult. It is not exactly that. So I'll slightly explain what we understand by evidence, what you can admit, what you can't during that kind of hearing and investigation. So let's start with the presenting officer role. Well, there is a difference between presenting officer and the investigating officer that Andy has been telling you about. There's an overlap. For example, the principles of running an investigation, admitting evidence will be quite similar. It's all the same thing. Fairness, the same thing. Involvement, self-reflection about what you do, it's exactly the same. But there's a lot of differences as well. Because when you are an investigating officer, you say, this thing just moves on to the next stage, whereas when you're a presenting officer, you can't sit on the fence, okay? And that is actually quite difficult because you need to make up your mind about what it is that you want from the committee, okay? So when you write your case, it must be clear what we are asking the committee to do. So in that respect, the role can be more challenging. So what does the presenting officer do? They read all the evidence, they prepare and write a coherent case, they review and add new information, and that's another difference between investigating officer and presenting officer. Okay? Investigating officer report is just one piece of evidence, well, the most important one, but one piece of evidence that you are going to use when you go to the hearing, okay? But you can add information that you feel is relevant to it in that time between the investigation and when the hearing is taking place. Your role will be to present the case to the committee, assist the committee, and that's one of the most important roles, because they will have a lot of documents in front of them, different people from different backgrounds and different institutions. And your job is to guide them through the process and through these complicated facts of the case. And the most fun one, question the student. And we'll talk about that a little bit as well. Before you begin writing your presenting officer case, you don't start writing straight away. Have a think about what it is that you need to do, okay? Firstly, remember it's a real situation. Many of us are academics, and it's very tempting to write pages of explanations of that we are thinking about. And this is not what your report is meant to be. Your report is all about facts, what happened. It's a story that is clearly put to the committee so that they can understand it and make a decision. That's why you start with the facts. What has happened? When did it happen? What was important? Who was involved? Before you look at guidelines. Okay? Guidelines are useful after you've got a clear picture of the situation. You then look at them, and they will help you to structure your case. Okay? Don't do it the other way around, because the other way around, if you know what you need in order to prove something, then you always find it, and then you'll miss a lot of other useful information that may be there in the case. By the time you finish your case, you need to be clear what it is that you want from the committee, and you need to know how to assist the committee navigating through the evidence. That's why one of the things you will be considering from the beginning is a creation of a bundle. Okay, as every lawyers very often have a bundle, okay, which I always also have, and making sure that it's signposted very well from the beginning, because that will come very useful when you actually go to the committee. So how do we think about preparing? Okay, so what are you asked to do, as we explained earlier on, because there are so many different procedures, sometimes it's not clear exactly what to do, so make sure you ask relevant questions so that you know what it is. Is it a fitness to practice committee? Are you asked to decide on whether students should be expelled or any sanctions? What's available? What rules are regulating what we are doing at the moment? And then you spend some time reading through the facts, absorbing them, analyzing them, without looking at anything else. Okay, very often you'll get a lot of useful advice from Rachel, and that is great. But what I do initially, I actually take a step back and look at all the evidence, just myself, without thinking about all the procedures and regulations. Okay, so I get a very clear picture of what I'm looking at. And when you start looking at the evidence, you will come across certain challenges. One of them is distinguishing between these three things, okay? First, facts and opinions, okay? And those also need to be distinguished from issues. And when you write your case, you need to be absolutely sure what the fact is. Okay, it can be mixed up with your opinion, somebody else's opinions, investigating officer's opinion. We need to be clear what the fact is, and opinions need to be kept separately. For example, okay, if we look on the right, I've listed some facts, so things that can be observed in this situation. And also, only after I've listed them, I begin to think, well, what are the main themes or issues within the case that I'm reading, okay? And I put them, literally, I've got like a big sheet of paper when I'm just writing these things down, okay? And then you can see that you can sort of, for dishonesty, you can pick the facts that are relevant for that particular issue, second issue, third issue. By the time you finish this exercise, you will know which of these is most important, yeah? Because you may have a lot of evidence for this, but much less on this one. And that, again, helps you structure your case, because you never start from the smallest issue. Yeah? You start from the one that is the largest. But sometimes when you start reading all the reports and evidence, it's difficult to see what is the most important thing. After you've done that, and the last thing, it was about opinions, okay? Opinions is very often, investigating officer will give them their own sort of angle on things, and that's very useful, and you will use it. But be clear that it is the investigating officer's view, okay, or university's view, not a fact, okay? Because this is how you write later on, how you use that evidence in your report, stating that in the view of the university, this is what it is, okay? Or that the investigating officer found that, okay, and then decided that, rather than this is what happened, okay? Because this can be very easily challenged, and if you do it in the wrong way, the lawyers will obviously identify it and identify the sort of the holes in your argument. Constructing a framework is something that allows committees to progress in a logical order, okay, and then decide and exclude certain facts as they go that are not relevant to the case. And what we use for structuring is guidelines, okay? Well, in court you would use the law, but in here we would use various guidelines that are in existence in our institutions. What I have done here, just to give you an idea how it's meant to work, I've used a personal injury legal case. How it's done in real life, okay? So it's not that lawyers come and they argue for half an hour and problem solved, okay? They always use a framework, okay? And they would use this framework in this particular order, okay? Because if A didn't owe the duty to anybody, then there's no point gathering evidence on anything else. Okay, you will fail on point one. Okay, no one is going to spend even a second trying to establish anything else. Okay, if you've established this, you see whether there was a breach of duty. You will have a lot of case law and statutes that will tell you whether there was or wasn't. If legally there wasn't breach of duty, then all these things don't matter. Okay? There's no point in spending a lot of time trying to establish them. Okay? So that's quite clear in law. It's less clear when you've got guidelines like other ones, but I did attempt to create some kind of framework for misconduct, because these are probably quite challenging cases to write about. Okay? So always starting again from evidence and seeing what those relevant examples of behavior are. And this initial bit shouldn't really contain any judgments about anything. It's really as if you were with a video camera videoing what is going on. Okay? After you've generated that, you see whether there is a clear and persistent pattern. Okay? It's very difficult to show that there is a problem with behavior if there is not a pattern. So you need to gather evidence that that pattern is indeed persistent. Does SGL provide opportunity to get to know the guidelines? That crops up very often, doesn't it? Yes, you didn't suddenly say, well, I've never been told that I can't deceive people. Yeah, I've never been told about this or that. Okay? So where are people? So bring it into your case straight away, because otherwise you spend 10 minutes during the hearing, lawyers saying, yeah, but have they ever been told? Okay, so just bring it in straight away so that there is clarity. And progressing through that framework. And as you write your case, write these things in order, because it helps then the committees to actually see it more clearly. As you're writing it, you will probably start considering various implicit questions, and those are, is my case strong? Do I agree with the investigating officer? Feel free to disagree. You know, it is evidence. Time has passed. You may have some additional evidence that is relevant. As you're writing, these questions will crop up, and you need to keep answering you as you go. And then you plan the outline. So we are moving towards writing now. Okay. The first thing I do before I start writing is a skeleton plan. This is not a skeleton argument that lawyers use in high court. It's just after I have read everything, I just write down bullet points what I remember. And this is going to form my skeleton plan. Because if I don't remember something, it was probably not particularly relevant, important, etc. I'm not saying you should exclude it, okay? But your skeleton plan is the most important things that you remember from the case. And then you fill it out as you go. Second point is the unity or coherence of your case. That's what you are there for. Okay, in order to assess the committee, they want to see clearly what happened from the moment it all started to the day the student appeared in front of the committee. They want clarity, basic statements, basic chronology, okay, or order of importance, if you like. But then very often when we start talking about the facts, we realize that there are things missing. Okay, I can't actually see how someone got from one point to another. And that's where you would be identifying the gaps, yeah, as you go. And you probably sometimes need to fill them in with evidence that you will need to gather yourself with the help, obviously, with our student affairs team. Okay, and shape and structure. So you've got your framework. You remember, we had a framework which you need to follow. But then, obviously, in your structure, you need to remember all these things. Yeah? Who is the student? What happened? What is the SGUL's case? Okay, so this is where you begin to think, where you're going to be. Okay, because investigating officer is not going to help you with that, because they only say it needs to progress to the formal hearing. Okay, of course the final decision is made by the committee, but you are the person who suggests to the committee what outcome you would like to get. Okay, because in front of the committee you've got two parties, each of them will be arguing, and on the balance of probabilities they will decide. Okay, so you need to be clear what you want. Now, keep reviewing your case, so don't just drop everything or exclude all the other evidence. That's it. Keep reviewing it. Sometimes evidence is not relevant, and then after you got to the end of your case, it begins to be relevant because you know a little bit more about it. So keep reviewing it. Make a very clear recommendation. Don't give the panel options. Okay, that if you do this, you should do that, or if you find this, then you should expel it. No, you just pick the one outcome that you want and put it in front of the committee. And the last one is incredibly important in hearings like this, because they are not judicial hearings. In court, one barrister will say everything that is against the client, the prosecutor, etc. And the person who defends will say all the best things. This is not how these committees work. Despite the fact that you will be representing the university and telling the panel what the university want, your case needs to be balanced. So if you know that the student has apologized, don't try to play down, okay? Just put it in your case that at this point they apologized, but from our perspective, they did not apologize until this investigation started, okay? So you are not playing down the fact that they have apologized. You just give a bit more context that it actually didn't happen straight away. It happened only when this big investigation started, which obviously gives the committee food for thoughts here. Otherwise, the lawyers will tell you, yeah, but you have excluded all the positive stuff, so clearly it's just a witch hunt, yeah? And you don't want that to happen. Now, in terms of writing, I don't have much to say, okay? So it's just a few lists that you've got in your handout. Don't try to do any of these things, okay? And just make sure it's balanced. It's very easy to read, logical, okay? That you explain the position and that you provide clear advice. Okay, and also a sort of checklist for various things that you should be including in your case. It's very good practice to include paragraphs and to number them, because during the hearing, it's very difficult then to find something, okay? If someone says, yeah, but on Monday the 20th of February, you said this, and then the whole committee is trying to find this, okay? Rather than you saying, can we all look at paragraph number 1.1.3, okay, which people can easily find. This is very useful. And don't include more issues in one paragraph than one. Just one issue, even if it's a short paragraph, because then again, it's much easier to navigate through your case. All other things we have discussed. Sometimes there is a question whether it should be chronological or not. In most cases, chronological order is best. And it's best to actually write the whole chronology. And very often, investigating officer will already have done that. Okay? But if they haven't, and you think that it's very important for the committee to know the timeline, then include it. Okay? Because I always find those timelines very, very helpful. Okay, so that's the presenting officer and what they do and the report they write. Okay, I'll come back to that when we talk about hearing committee, what a presenting officer does during the hearing. Okay, so that was all before. So that's the composition of your hearing committee here at St. George's. Okay, so there's not that much really to say, apart from the fact that you will have 3 external appointments, 1 appointment from another course, and 3 internal. Okay, so it's not just myself and the course director, head of year, and the student's personal tutor or something, okay? It's a range of people, and this is sort of, we need to show as the institution that we are objective, okay? Right, this slide I've generated to give you an idea of where the committees like that are placed in comparison with what happens in legal practice. Okay, because that refers to the point of fairness. Sometimes we exaggerate the level of accuracy that we need to have in our work, which is quite unnecessary. No one does it, and we don't need to do it. So you've got your criminal civil proceedings, then we've got fitness to practice here at St. George's, then we've got disciplinary panels, again at George's. We've got a variety of those panels, and then judicial review. Okay. Now, firstly, you need to always remember the aim why these committees operate. Okay. So the court, if somebody kills someone, the aim is to punish. Okay. You don't need to do. Sometimes it's public protection, but these days it's mainly to punish the person. Okay. For civil, it's damages. Yeah, you broke someone's leg, they want money. Okay. So damages would be the main focus of the case. For fitness to practice committee, it will be public protection. Okay, and we talked about that earlier on. It's not all about the student. Okay, the aim is to protect the public. Disciplinary panels, public protection, but also sometimes to put the matters right. Okay, and then something that can be corrected, where you can get the person to correct that behavior. And then judicial review I included because if our cases fail, they may be judicially reviewed. And this is not that someone is going to sue you as an investigating officer or something like that. This has nothing to do with suing, because these courts don't deal with facts at all, okay? They deal with procedures. So if there's something wrong with the procedure at the level of the university, they can review them, but their aim is only to prevent abuse of power, okay? So it's not their job to decide that Rachel at some point forgot to send a document to someone. Okay, so that's not what they are doing. What they are doing is seeing whether our procedures do not disadvantage the student in a way that is inappropriate. And there are certain processes for that. Okay, and then who brings action? So obviously public body in our case, prosecutor, for example, for criminal. Standard is very important. It's the balance of probabilities. I'll talk about it in a second. Not beyond reasonable doubt. And that's important, firstly, because very often we think that we need to prove everything beyond reasonable doubt. Secondly, that standard did operate in the past in fitness to practice committees. So over 10 years ago, the standard would have been different. We have a burden of proof, so students don't need to prove anything really, but they have the right to defend themselves. Okay, so that's really important. Area of law, public, and then the outcomes, okay? Sentence for criminal. We are not sentencing students. We are not penalizing them, okay? That's not what we do. Not remedies. We don't give remedies to people who were affected by their actions, okay? You will never have an outcome like that in fitness to practice. You will have sanctions, warnings, expulsion, yeah, that kind of choice. And for judicial review, they will just tell their university to go back and do it again. Change the procedure and do it again. They will not tell them that the presenting officer was rubbish and they need to go to jail. Because sometimes people don't want to take on these cases worrying that if I do something wrong, you know, am I going to be sued or something? Well, no. Well, if you slap the student, then of course, but that applies to any area of your job anyway, okay? So you would need to be worried about that all the time. But from the perspective of our procedures, it is not you who is going to be sued if something goes wrong. Okay, so have courage. Okay, don't be put off by the fact that sometimes lawyers can get engaged. Now, overriding principle is something again that helps you to think about your case, because that applies to any case that goes to court. Okay, and the focus. I'm not saying that you should read all that, but the magical word here is proportionality. Okay. And going back to the case when the case goes to the High Court because, for example, we didn't follow our processes or something like that. The first question that is going to be asked is about the proportionality. So if student thinks that we should have interviewed 150 witnesses and then attend, I don't know, a club somewhere and stand there at night and observe whether they are dealing drugs or not, then obviously the question of proportionality will be considered. Okay, we are not the police service, we are not secret service, that's not our job. So depending on what is expected of us, what resources we have, and the difficulty or seriousness of the case, different things are expected. So something different is expected when someone murders somebody to when someone slaps somebody else on the face, okay, or forges a signature. Now, in terms of evidence and admissibility, because you will need to decide whether things that you've got in your bundle can go in front of the committee. Okay, and that used to be a much more complicated exercise. So firstly, you need to think, what does the committee do? Okay, in what way are they going to decide? Do I need to persuade them beyond reasonable doubt that it happened? It turns out we don't. Okay, so the standard of proof that we use in these panels is balance of probability. And I've got a sort of extract from the judgment from 2008, and this is what Baroness Hale said at the time, and perhaps take a moment to read it. You only need to be one step ahead of your opponent, okay? That's all you need to do. So when you're looking at your evidence, all you're looking at, is it actually adding something to my case to persuade the committee that I'm right, not the other party is right, okay? There's a caveat to it, which I'll explain later in terms of fairness, okay? But generally, you don't have to agonize about being always 100% right or having always evidence that is always of the best possible quality. Because, for example, in criminal courts, poor quality evidence is, for example, an excellent letter written by an expert who forgot to sign it, okay? And that's no longer a good quality evidence, yeah? So obviously we don't have to worry about these things to that extent in these investigations. So I included sort of the General Medical Council Rule 34, how they address the issue of balance of probability and the quality of evidence. And I included the old one, and you'll see that in the old one, it was the criminal standard. So you had to prove everything beyond reasonable doubt, and your evidence would have had to be really, really good quality. And that's very impracticable for institutions like this one or any public institution to do it. So it no longer is there, but instead we've got something that is called fair and relevant. Yeah? So it's not only balance of probabilities and sort of Brexit kind of debate, okay? There's a bit more to that, okay? So yes, you can try to persuade everybody, but it will all need to be also fair and relevant, okay? So it's a little bit of a hybrid between civil and criminal here. So when is something relevant? When it's probative rather than prejudicial. So if someone stole, if the case is about theft, okay, and you can show that someone has stolen other things, 7 times, then it is good evidence, yeah, it is relevant. But if they've stolen something, and then this morning they didn't flush the loo, then probably it doesn't put the student in a good light, okay, but it is not really probative, yeah. So irrelevance, there is very often they may have had a conviction for driving or something like that, which will not be probative, it will just be prejudicial. Okay, because the committee will say, oh, that's a really horrible person, okay? They will usually have a slightly different angle to the person. So you don't want that. You don't want evidence when you need to spend 45 minutes explaining it to the committee, because it's probably not relevant, okay, if it takes time to explain the relevance of it. And the relevance is more about advocacy. So how does it fit within the whole picture, okay? How does it advance your case? And how does it provide more information about what has happened with relation to this case? It's not a legal argument, okay? It's not, you don't need to sort of use any kind of legal principle in order to do that, okay? And the second sort of limb is fairness. And this one is really difficult. Firstly, sometimes because we feel sorry for these students very often, we don't want them to be in this situation. We want to apply this absolute standard of fairness that doesn't exist anywhere, even in criminal courts where the standard is very high. So what do we do? Well, obviously this is where lawyers will always be coming up with various things. Okay, and one of these things is Article 6, okay, so fair trial, so whatever we do is unfair, okay, so always say whatever sort of the order is wrong and we are unfair, and it's Article 6, there's always Article 6. Disability legislation, all sorts of legislation that should be taken into account but hasn't been taken into account, okay? And the reason it crops up in the hearings, because students bring in disability only at that stage. And then we are criticized that we didn't take that into account. Well, of course not, because we didn't know, yeah? But we do need to consider that. And another thing that will be very often challenged is that what you are putting in front of the committee is hearsay. Hearsay is anything that hasn't been said by witness directly. So either you have a person there and they say it, or you show a video of what happened, or you've got a statement that is signed and dated, and it says on it that I sort of certify it as the true copy of my statement. Yeah? If that is missing, for example, in criminal court, it wouldn't be acceptable. Okay? It's not as bad in our hearings, because we, as in civil proceedings, can accept hearsay. Not a hearsay, because like we understand sometimes, not that you heard something on the lift and you use it. Yeah, so not that kind of hearsay. Okay? Hearsay where, for example, suddenly you get a sort of written report from a consultant from the hospital, but it's not necessarily signed, okay? But it does come from them, okay? You can put it in front of the committee. Okay, so there's many things you can put in front of committee, which is quite a relief. The only thing you need to do, though, is to give the student notice that you are going to be submitting it. Okay, so if you don't give them notice, you submit it on the day, and it's hearsay, you can't. And then there's no point arguing with the lawyers at that point. I had that situation before. And obviously, it is a no-go area. And then they obviously can link it into the fairness things, that we admitted it, but it was unfair. You start from the beginning, okay? Now, note that it's only for hearsay. If you suddenly, 1 second before the committee have a statement from the consultant that is dated, signed, and it says that it is a true thing, that is not hearsay, okay? You can admit it, okay? So if you can arrange that kind of evidence, then they can argue until they rupture, and you can still introduce it, okay? But hearsay is different. Now, this is very useful because we hardly ever can have such a high standard of evidence, okay? So very often we do use hearsay, and everybody is used to that. You just need to have confidence in doing that, okay? So sometimes it may not work for you, okay? But then you have got, I've never been to a hearing where lawyers didn't introduce evidence on the day. Okay, so if they do, well, then I do. Okay, they can't then say, oh, but you should have done that 15 days before. Do you know what I mean? So sometimes they sort of ruin that for the students as well, yeah? But generally, yeah, in advance. But as long as you let them, give them a chance to respond, okay? It's more about, sometimes you can bring it on the day. If it's something simple that student can, using the resources they've got, which is their brain basically, defend themselves, then there's no problem. But if it's something that someone else said, then obviously there's no witness. We can't possibly on the day do anything about it. Okay, so that would be much more challenging. That's why I would just get them to sign it and everything, all singing and dancing. Now, I only told you that not because now you need to go home and think about all these rules, how you're going to run it. This is all administered by Rachel and her team. So they keep thinking about all these principles. And whatever the processes we use already encompass all that. It's just more to give you an understanding how it all works and perhaps reassurance about how it all works, okay? And sometimes when we say, oh, no, you don't need that, you don't need that, it's not because, you know, we believe that we can just have a rubbish case. It's because sometimes we just don't need certain type of evidence to be admitted at all. Okay, so we are hopefully best practice. As Aileen said, it looks like we do have good procedures here at George's. So this is our current order of the hearing. To sort of study it, you will have it in front of you every time you are in the committee, but you will see that part of it is with the student and the representative present, and then at some point they withdraw and the committee will deliberate in private. Okay, so all those deliberations will take place in public, in private. Obviously, more recently, we have adjusted the order, and I think that's fair enough. In courts, the defendants usually speak last. Okay, so why should students not speak last? So I think it was a fair change to make. They should have a final say. So let's go back to the SGUL, presenting officer. What do they do at the hearing? Okay, so firstly, they present the case, okay, to the committee, okay? So the chair, after doing all the business at the beginning, will ask the presenting officer to present that case. And I'll just share my own view on that. Different people do it differently, so feel free to experiment with different things. But I don't read the whole thing once again to the committee, because people would normally have read it, okay, and there's just time passing, students getting exhausted, okay. It's just really tiring when you need to read all of it. So what I say is, you know, I check with the committee whether they have had an opportunity to read, although they would probably never say, oh no, we haven't, we have just turned up. But you do need to check, yeah? So you check, yeah, we've all read it, fine, we know the case. So, you know, with the permission of the chair, may I just take the committee through the main points, okay? And just tell them the main points of what has happened and what your case really is, rather than reading it all out. But this is just a general guidance. Sometimes you may judge that actually reading it all will make better sense, okay? So you really need to judge for yourself a little bit better. Student will present the case as well, and you've got nothing to do with it, luckily, but you will need to respond to the student's case. So your listening skills, incredibly important. You need to listen to what they say. They never say the same things as they submitted earlier on, Okay, so you need to pick these things up. I think this is the more difficult, because you're already exhausted from the presenting, and now you need to listen to people saying something, and you're writing down various questions. So you question the student, usually on the new material. Don't ask student questions about material that you've already presented to the committee, because you should have asked about that before. Okay, so you mainly ask about things that have been introduced that are new. You can challenge the new evidence. It's in brackets because it's very dangerous. Okay, so I'll talk about it in a second, and then summarizes the case at the end of the whole hearing. On questioning, okay, I know that it sounds very fascinating and exciting to cross-examine someone, okay, and you can, a student or a witness. I've never seen witnesses coming, but if there was such a chance, you can question them. But first question, if you are given that opportunity, ask yourself, is it really worth it? If what they say didn't really make any difference to your case, then just move on, okay? Because by questioning, you may introduce material that is going to destroy your own case, okay? Because you don't know what they're going to say, okay? So only if it's really something, and very often it's those evasive answers that you want to explore in your questions, okay? They say, I don't know, no, I no longer remember, I was too tired, I am too tired. I agree with most of the allegations we had recently. Yes, so the student was saying we were almost asleep because we were exhausted, and they said, I agree with most of the allegations. Yeah? Oh, well, what do you mean by most? So which ones do you not agree with? Okay, so that's really important. If you miss that, then obviously they will have case later on because they said that they don't agree with all the allegations. Okay, so you need to sort of listen as we go. As a general rule, I don't lie. Okay, so can you expand? So in what cases do you lie, okay, or do these things, okay? Or when they say it really doesn't matter, okay? So for example, I don't know, an interaction with a receptionist was inappropriate. Suddenly it didn't really matter, okay? And usually they just say it as an add-on to what they said, something else they said. So you need to listen carefully, because very often important things, when you judge the insight of a student, are hidden in those answers. Okay, what insight do people actually have? And most of our cases actually revolve around the insight that students have or not. Okay, so what they present is like in an OSCE examination, they will always be just polished, particularly when they come with lawyers. So polished, it's fantastic. Okay, but then they add these things, and when you start asking about it, you will see whether they've got insight or not. Okay, so again, don't ask questions if you don't need to. Okay, now if you do ask questions, make it simple and clear. Okay, don't make a big introduction and then question at the end. Okay, because student is not going to. They're too stressed to even process that. Ask for facts, not for opinion, who thought or who said what. Okay, sometimes for opinions, but it's a very rare thing when you're trying to sort of talk about, sort of explore the integrity of the students, what they thought when they saw someone else stealing something. So sometimes questions like that can be useful. But in the main body of your questioning will always be the facts. So you may also end up being a chair. Yeah, chair for the hearing committee, yeah, not only presenting officer. So that's what they do. So this is again a list. But I think what I would say is if you're chairing the committee, take control, okay? If the barrister comes in, you are in control and you say what is happening. And they've got nothing to say, okay? Because our processes are made clear to them. So if you follow the process, there's nothing they can do, really, if you say that you don't do or don't want something, or if you want a question or you don't. Particularly if you see that the lawyer is sort of dealing with the presenting officer in a way that is unacceptable. Yes, it's your job to stop it, take questions, and say, no, you can ask questions through me, okay, through me, and then just monitor the behavior and correct that behavior. Okay, you have to intervene if you feel that the representative, that is not very often, because again, I don't want people to terrify that lawyers just come in and I've had that situation once, but actually that was quite exciting because the lawyer was completely not prepared, so it was very easy, and I've got a checklist again, what to do if they shout and scream and try to, suffocate, strangulate you there. In general, presenting officers shouldn't be questioned, cross-examined, because they are not witnesses. They are not a student and they are not witnesses. But sometimes we allow people, just for fairness, to ask questions. But again, if you're here as the chair of the committee that, no, we're going too far. Just stop it. There is no law preventing you from intervening in this situation. Okay? But there is actually law saying that if you don't intervene and someone judges this hearing as unfair, then there's going to be a problem. Okay? So that's what you are there as the as chair. And the final bit about representatives. So we obviously mentioned representatives very often. Sometimes we have them, sometimes don't. I've had incredibly positive experiences very often. If you think about it, you want the barrister to be present. And that goes back to the standard of proof, because it's not beyond reasonable doubt. You don't want to leave the hearing, go home and think, actually, I don't think that that he's done it. Yeah? So having a lawyer is great because they will fight the case. And if the committee is still persuaded that the student is at fault, then obviously you can be relieved that we've done all we could to make sure that the situation is, that the hearing is fair. And they will present, and that's what they will tell you. Well, I'm very sorry, I'm just presenting the best possible case on these facts. Okay, so if we were, I know that it's very often not true, and people roll their eyes. So what are they talking about? That's the role of the defense lawyer. They present, if you put together all these facts, none of us was there, so the best story you can generate on these facts is this. Okay, and then the committee needs to decide how important this is. So that's what the best lawyers are going to do. And it's actually a very rewarding, very good experience to go through. But the preparation will vary. In most cases, they're not, because they are very small cases. They just read it on the train to the university. So the best thing you can do as presenting officer is know your facts well, because they don't. Okay? You will easily catch them or not knowing what has actually happened, which is actually terrible for the students because they pay a lot of money, okay? But that's, again, your job, okay, because you are protecting the public. And I've done things like, yeah, the student said this, and the lawyer said, no, where is it? Where is it? No, it's never been said. And I sort of wrote down exactly the minute, second on the recording where the student said it, okay? So you need to be quite, obviously not everything they said, but some more sort of important bits. Okay, so that's your little checklist. I wanted to sort of think about how to deal with the representatives on the day. But as I say, the main person to deal with the representatives should be the chair anyway. Okay, and just sort of handling. Now, one thing I have actually not said, but it was on the slide, is representatives are not there to speak for the student. Okay, students need to speak for themselves at all times. In a very rare situations, the chair may decide otherwise. In most cases, you will say, no, we want the students to speak because you need to judge the inside as well. Not only facts, okay, but also the insight the student has. And if it's just the lawyer talking, you won't be able to have that.